Welcome to Talk Law Radio with attorney Todd Marquardt of the Marquardt Law Firm at marquardtlawfirm.com.
Welcome to Talk Law Radio. I'm Todd Marquardt, on the radio, on podcasts, on Facebook Live, and on YouTube. Also, go to www.talklawradio.com where you can search for archived episodes. If you're interested in finding out about the law or regulations, you can listen from there, or you can go to YouTube. Just search for Talk Law Radio and look for the Lady Justice holding the scales of justice and the red, white, and blue logo. And do us a favor and click subscribe. And then that way, when we drop new episodes, you can be receiving an alert. So today I'm going to be talking about the hidden legal issue blind spot of qualifying for nursing home Medicaid and what are the requirements for you to be able to keep your house. You see, Medicaid is a program that you can qualify for and still keep your house because it's an exempt resource, or it's a resource that you're allowed to keep. There's a lot of resources that you're not allowed to keep because the general rule is you have to have less than $2,000 in valuable assets, but you can still have a house, so that's not included in that $2,000 mark. But there's a Texas Supreme Court case that recently weighed in on these rules, and so that's what we're going to be talking about today. Talk Law Radio is sponsored by Marquardt Law Firm, and attorneys at Marquardt Law Firm focus on business and estate law, including last wills, living trusts, tax-protected inheritance plans, and new businesses and old businesses which might have issues with corporations, contracts, LLCs, and family limited partnerships. Also, we can help out for those who have had lack of planning and end up in district court, county court, or probate court. We've recently welcomed a new attorney, Stetson Honey. He's from Abilene, and he used to work in a title company, so he has a strong focus on real estate. He's going to be helping us with probate and guardianship for this year. And also, I'm helping people out with nursing home Medicaid, and so that's why one reason I stumbled upon this case is because I have to keep up with the regulations and the law. But this episode should not be construed as legal advice. We can only give legal advice to clients, but the State Bar of Texas does like for us to give information to the public. But just know that legal advice has to be tailored to your specific circumstances, your facts and circumstances. And so just consider this to be general information today. And if you think that you're interested in finding out more, well, visit an attorney or call Marquardt Law Firm at 210-530-4278, or learn more at marquardtlawfirm.com. That's M as in mother, ARQUAR, D as in David, T as in Timothy, lawfirm.com, and you can read all kinds of articles there. You can also go to Marquardt Law Firm on YouTube and watch some short videos that I've produced during the COVID era. Okay, back to Medicaid and nursing homes. Now, a lot of people will say they never want to end up in a nursing home. But sometimes that's the standard of care that a person needs when they're chronically disabled or suffering from Alzheimer's and dementia. And so I meet a lot of family members who want to take care of their loved ones, their older or disabled loved ones, at home, and they try and do that as long as they can. But you have to watch out for two things. Number one, is that the appropriate level of care? Are you able to to do the job of a caregiver or a nurse, or do you need to take them somewhere where they can receive more specialized care? And number two, watch out for a caregiver that's getting burned out, or even worse, having a heart attack because of the stress on their body. So sometimes the caregiver needs to place their loved one in a nursing home just so that they can take care of their own body and their own wellness. So watch out for those two things. Is it the appropriate level of care, and is the caregiver getting stressed out? Because what happens if the caregiver, God forbid, tragically dies and the elderly disabled person is left alone? Then for sure they would have to be in a nursing home, and maybe the caregiver is the only one that would be able to visit. So that's one of the reasons I like to help people with this, is to help the elderly or disabled person get the care that they need, and to help the caregiver get the break that they need. And then they don't have to be a caregiver. They can be a visiting family member or a visiting loved one, and they're not holding the big responsibility of taking care all day long, all night long. So the court case I'm going to talk to you about is styled Texas Health and Human Services Commission versus In Re Estate of Burt. This was decided May 3rd, 2024. What happened is this elderly couple sold their house to their child, and they went to go live in an apartment. Several years passed, 7 to be exact. They moved into a nursing home, and as part of their strategy to get qualified for Medicaid, they bought a fractional interest in their child's home that they had just sold 7 years previous. And so they had less than $3,000. So a married couple is allowed to have $3,000. If you're a single person, you're only allowed to have $2,000. Well, their application for Medicaid was denied because they owned a resource that Medicaid said was not exempt because they didn't live in the house. They had come to the nursing home from that apartment. And the applicants or their agents acting for them appealed that Medicaid decision so that they could have a hearing and have a hearings officer decide whether that was correct or not. And the hearings officer denied the appeal and upheld the agency's decision to deny benefits. And so the couple appealed to the district court, and the district court reversed the denial, said that the house that they had a fractional interest in was exempt. Well, the state of Texas appealed to the Court of Appeals, and the Court of Appeals upheld the district court's decision, which was to reverse the denial. And the state again appealed that decision to the Texas Supreme Court, and the Texas Supreme Court found that the reversal of the denial should be overturned, and I'll go through some of the reasons that they did that, ultimately finding that the state's decision to deny the application should be the correct result. So let me explain some background on this strategy. So I started this episode by saying that somebody could qualify for nursing home Medicaid and still have a home. And the philosophy or the reasoning behind that rule is that the person that's going into a nursing home could get better, and then they need to go back home. And so the legislators, the state's view is that they don't want you to sell your house and spend all the money, end up in the nursing home, get better, and have nowhere else to return to. So that's why they allow you to keep your house and still qualify for Medicaid. So there's 2 periods of time we have to worry about the house. One, when we're filing an application, and 2, after death. You may have heard about the Medicaid Estate Recovery Program. M as in mother, E-R, P as in Paul, Medicaid Estate Recovery Program. That's where the state made a rule that says that after you pass away, you need to reimburse the state for the amount of money that the state spent on paying for your nursing home care. Because nursing homes are private businesses, and so the benefit is that Medicaid pays them the difference between your income and the cost of care. So your income is the co-payment, then Medicaid supplements that to cover the cost of care. And after you pass away, the state wants to get reimbursed for that. So that's the second time that we worry about the house, because in Texas, you can have your cake and eat it too. You can qualify for the benefit and keep your house regardless of the Medicaid Estate Recovery Program if you use a ladybird deed or a transfer on death deed. So that's what the couple did here. They bought the interest from their child and then later signed a ladybird deed so that upon their deaths, the house would be owned free and clear by their child. And so when you do it that way, then Medicaid Estate Recovery Program doesn't have a method of getting the value from that house. So the only people that lose their homes to Medicaid Estate Recovery Program are people that don't know about this. This is a hidden legal issue blind spot we should pay attention to, or people that don't like lawyers. Because if you see a lawyer and you tell them that you want to qualify for nursing home Medicaid, they should know about this. And if they don't, you need to find a different lawyer that does. So tell your friends, tell your family, and make sure that you're doing all you can to prevent problems like losing the house to Medicaid Estate Recovery. Okay, there's another rule that says when you apply for Medicaid, you need to tell Health and Human Services whether or not you intend to return home. So, like I said before, the state will allow you to keep your house if you intend to return to it. And I have a lot of clients that I'm beginning to help, and then I tell them about this, and they say, well, mom or dad or whoever is never going to be able to return home because of their medical condition. And I say, well, how do you know that? You're trying to predict the future. In order for us to protect the home, the patient, the Medicaid recipient has to have the intent to return. And so I ask them, if your mom or dad or loved one got better, would they want to go home? Of course they would. So you have to make that known to Health and Human Services. I told you about the house as an excluded resource. You can find this rule in 42 United States Code section 1382B. It says exclusions from resources. In determining the resources of an individual and his eligible spouse, if any, there shall be excluded 1. The home, including the land that appertains thereto, household goods, personal effects, and an automobile to the extent that their total value does not exceed such amounts as the Commissioner of Social Security determines to be reasonable. So that's where the $2,000 rule came in, I guess. So the court hung their hat on allowing the agency to deny this application based on the definition of home. Because remember, I said that they had once lived in this home, they sold it to their child, they moved into an apartment, they moved from the apartment to the nursing home when they needed that level of care. And so under these rules, the Medicaid applicant could presume that if they bought an interest in a home again, that would be their home. And so I'll read to you some parts of the opinion that explain why the court came to the conclusion that they did. And one definition under CFR section 416.1212 defines home as any property in which an individual and spouse, if any, has an ownership interest and which serves as the individual's principal place of residence. But the court went with the plain and ordinary meaning of the word home interpreted in the context of the statute, noting that dictionaries define home as one's principal place of business or domicile. A home is the principal place in which one lives and resides, not merely a structure in which one possesses a partial ownership stake. At the time the Burts, the people in this case, applied for Medicaid, they did not reside in the house, nor was the house their principal residence or domicile during the preceding 7 years, because they had been living in an apartment. So the court reasoned that under the plain language of the statute, that house was not their home. So you have to pay attention to these things. And so the lesson that we learn here is that if you're going to apply for Medicaid and rely on the home as an exempt asset, you need to have lived there before you move into the nursing home. So what this opinion essentially does is it's a judicially created prior occupancy requirement. You have to have lived in the home. So if you have questions about the law, this law, or any regulations that seem to be bothering you, let me know. Email me at host@talklawradio.com. That's HOS as in Sam, T as in Timothy, at talklawradio.com. Or you can text Todd, that's me, at 210-538-4770, 210-538-4770. Text Todd any laws or regulations that you're wondering about. So there are other government benefits that one could apply for in addition to nursing home Medicaid. There's the STAR Plus waiver program, which is a Medicaid home care program. It's different than the nursing home program in that it's not an entitlement program. Entitlement programs like nursing home Medicaid are for anybody that qualifies, but the STAR Plus waiver program has limited funds, and so not everybody that qualifies can get those funds. So there's a waiting list, and some ranges from a few months to a year or more. At one time, it was over a year long. So that's another way of getting help for your loved one if they're disabled or elderly and need help at home. Other Another program that's popular in San Antonio is the Veterans Pension with aid and attendance. And the reason it's popular is because San Antonio has a large population of veterans, people who trained here, who went through boot camp here, served in the military for a few years, and then come back, or they grew up here. But I meet a lot of veterans who lived here for a short time, left, and then they returned when they retired. And so if you know a veteran who served during a period of war, like Vietnam or Korea, then they might be entitled to this pension. They have to have served at least 1 day active duty during a period of war. They also have to have been honorably discharged, or at least not dishonorably discharged, and they have to be over 65 or disabled. And they have to have low income, low assets, and high unreimbursed medical expenses. So if you know anybody who's suffering because they need help with activities of daily living like showering, toileting, transferring, eating, and those kinds of things, they might need to have a caregiver. And it might be you, or you might be paying out of pocket for a private company to do that. And what I would suggest is don't wait to apply for government benefits when you're completely broke, because it takes some time to get qualified for these programs, and you might want to apply before you're broke so that you have a little bit of money to get through the time period from the application to when you're actually approved. So those are some benefits, and attorneys at Marquardt Law Firm do provide representation to elderly individuals and their caregivers to help them qualify for government benefits. Now, you could go straight to the source. You could go to the Medicaid office. You can go online. Medicaid even has an app called Your Texas Benefits, and you can apply yourself. But you might make a mistake, or you might not do things in the right order, which might cause you to lose money. So if you want things done the correct way and the correct sequence of events, you might want to hire an attorney for that. Now, if your loved one is already broke, then it should be easy for you to get them qualified. Something else, if you apply for VA benefits, the VA very much wants you to deal directly with them. So you can file a VA application online, or you can go down to the VA office and they'll help you fill out the forms, or you can go to the VFW or any veteran service organization and they'll help you fill out the forms. But what they can't do is give you legal advice on the strategies for getting qualified if you have too much money. Now, if you're already broke, it shouldn't be hard to get qualified. But in addition to these government applications, there's a whole bunch of other documents that have to be submitted for both of those programs, because for every question on these applications, you have to provide a document that proves your answer, all the way down to the picture ID. So you have to prove that the applicant is who they say they are, and lots of other things too. So you heard it here on Talk Law Radio. If you know somebody who needs care, like in assisted living, home care, or nursing home care, you might want to call an elder law attorney like Todd Marquardt at Marquardt Law Firm and get some advice on what to do and what not to do, what's legal, what's allowed, what's above board. We always show our work. and tell your loved ones and your friends. And if you're agent under power of attorney, we can help you understand your fiduciary duties under that document as well. Or if you're a trustee of a trust, what are your responsibilities? What are your duties? And how do you do a good job? Because sometimes implementing the rules, following the rules, and the real world, you need to know exactly what you can and can't do, or what you should and what you should not do, and how to benefit your loved one. So I think that's it for today. Thanks for listening. I'll talk to you later.
This has been Talk Law Radio with attorney Todd Marquardt, brought to you by the Marquardt Law Firm. You can learn more at marquardtlawfirm.com. And be sure to listen to the full Talk Law Radio show Saturday mornings at 11 on 9:30 a.m. The Answer.
Each week, attorney Todd Marquardt talks about the law. His mission with the Talk Law Radio show and podcast is to help you discover your legal issue blind spots. In the beginning, God had one law. Don't eat from the fruit of that tree. Then came the Ten Commandments. Now we have federal, state, and municipal lawmakers that won't stop creating new laws. Laws that might impact you without you knowing it. Listen to the show and drop a line on Facebook or email host@talklawradio.com and let the host know what you think of the show, the topics you want to hear, and whether you want to be a guest.